Well, the clock on the friendly mercantile says it's 1 o'clock Central Time, so we'll get started. Welcome to DOT Driver Qualifications and Background Checks. I'm Mike Coffey, President of Imperative Information Group. I'm an HR guy. I've been in and around HR for a couple decades and then some, but we'll just hold it at 20 years now. I've been president of Fort Worth HR. I'm still on their board. I'm a district director for SHRM, a board member for the Texas Association of Business, and been very involved as well in the background screening industry. Imperative Information Group is a background screening and business due diligence firm, so we spend every day helping our clients make well-informed hiring decisions and keeping criminals, creeps, and crazies out of their organizations. But that's all the sales pitch you're going to get from me today. Everything else I'm trying to sell today is going to be about doing the right thing and staying in compliance with the FMCSRs. And there will be times where you hear the gospel according to Coffey, my own take on how to comply with some of these regs, and I'll point out where I'm really dealing with some of my opinions. You're not going to get a lot of that today because this is pretty clear-cut stuff. So let's do a poll here. How many of you have DOT covered drivers? I'm always curious because I know some people are on this because they need the HRCI certification credit, and that's fine too, but just curious to see. So if you'll just let me know if you have DOT drivers. I'd be curious to see what we have here. I don't mind you just, I imagine there's some people who need the credit who show up at the beginning of the webinar and then go to lunch or something, but that doesn't hurt my feelings either. Well, let's close this out real quick and see what our results are. And it looks like about 3/4 of you, a little less than that, do have DOT drivers, and another quarter of you don't. And I imagine those of you who do have DOT drivers, you're not going to hear much today that's really different than what you're probably already doing. Although I do have, some clients and friends who get as confused as I do sometimes about how all these different parts of the FMCSRs apply to them. I want to do another survey here. Who currently handles your DOT mandated background checks? A lot of employers are doing those in-house while others are, let me turn the slide off, hide that. While others do outsource it, sometimes it's safety. So let me share this one. Let me launch it. Okay. So who currently handles your DOT process? Is that HR, safety risk management? Is it somebody internal? Or is it your background investigations partner? Just curious to see how that flies. It used to be, it was almost always safety and risk management, and I noticed back in 2008, 2009, when the economy imploded, a lot of those duties got shifted onto HR folks, and they often weren't really aware of what they were doing. I still talk to HR folks who are doing what they thought they were told to do 5 years ago, and then the auditor comes in, and then they find out, oh, well, you're not doing it right. So let me share these results. So, yeah, it's about half of you goes to HR, and the rest is split between different departments, and a big group of you are outsourcing it to your background screening vendor. And certainly that's what a number of our clients do as well, which is why we're having this conversation. Let's go to the next one. How well do you think you personally understand the DOT requirements? I think that's, oops, I hit the wrong button. Give me 2 seconds. How well do you understand it? There you go. Curious about, well, very well or pretty well or okay or not very well, and hoping we don't get audited. And usually it's about half or so say, yeah, we're doing it and we hope we're doing it right. So I'll give it a couple more seconds here. Go ahead and close that. And let me share those results. So yeah, well, again, about half of you said, yeah, feel somewhat comfortable with it. We're just not, I'm not sure we're doing everything right. And a few of you think you ought to be teaching this, and that'd be great. If somebody else wants to teach it, I'd love to just to host it and let you teach it, so let me know. And let's see, hide that. Okay. Great. And how well does your current process work? I'm curious about that. And I promise this is the last one, but it's helpful to kind of get an idea where everybody is. And hopefully it'll help you understand there really are no dumb questions. Kind of get an idea how the rest of the people on the call are feeling about things, so we can hopefully get some feedback. Okay. 5, 4, 3, 2, 1. I'm going to close it and share those results. And so most of you think it goes pretty good. It could run smoother. I'm sure that's mostly previous employment inquiries and waiting for other employers to give their responses. Some of you, it's not great, but some of you think it's going pretty well. I hope those are our clients. I'm going to go back and double check when we're done. Okay. Then let's talk about what we're not going to talk about, okay? I'm not really getting into the DOT drug screening process today, because that could be a whole webinar into itself and what's required there, or the substance abuse providers or rehab programs, those kinds of things. We're going to touch on a couple of those with regard to the previous employment inquiries, but really not into what the actual program requirements are. I'm not going to talk about driver physicals or road tests or really DQ file maintenance. We're going to talk about the investigative file, but not really the file, the regular driver qualification file very much. So what we are going to talk about, the FMCSRs that affect driver background checks, the employment application requirements for motor carriers, inquiries to previous employers and what those employers' responsibilities are in responding, and what driver disclosures are required by the former employers and by the prospective employers. So we'll get into all of that, which is plenty to talk about in an hour. So the Federal Motor Carrier Safety Administration is the group that handles driver. Give me 2 seconds, guys. I'm sorry, I'm having a screen freeze here. Here we go. Let's try that. That's better. It's part of FMCSA is part of the DOT and is what you would normally find as the regulatory agency for motor carriers. And they do cover interstate and intrastate carriers. It's one of those things where, depending on what kind of I am having technical issues with GoToWebinar. Give me 2 seconds, guys. I apologize for this. Love it when a plan comes together, but let's see here. There we go. Let's try it again. Sorry about that. So the FMCSRs can be sometimes confusing. These are the rules for the road, rules of the road for motor carriers in the U.S. And they're kind of a maze. The regs, they seem to overlap each other, and for some employers there really are two different sets of rules for the exact same driver, and so there's some things that confuse you. Also, what determines whether you're an intrastate or an interstate carrier isn't always clear-cut. Intrastate typically means that you only operate inside your one state, across state lines. However, if you have loads that originate in one state and terminate in another state, and you pick them up and take them to their final location, that can make you an interstate carrier, even though your vehicle or driver never crosses state lines. So that's something where you really want to talk to your DOT experts to make sure which of these sets of regs do we really fall under. And feel free to ask questions throughout the webinar. I will come back at the end and answer them all, but feel free to punch the questions in as you get them, and we'll go over them at the end. So when we're talking about background checks, there's really 3 areas that really cover the background check process. Part 382, which incorporates Part 40, which are the requirements for how drug testing is done. But Part 382 incorporates it specifically for motor carriers. Part 383 covers commercial motor vehicle driver's licenses. Then Part 390 and 391 covers the minimum driver qualifications and the record keeping for interstate, so more than one state carriers. So some of this is going to apply to some employers and not others as we get through it. So first of all, what is a commercial motor vehicle? Let's get into that, because and you've got 2 different definitions. Here we go with 2 different sets of definitions, and it's going to really depend on the size of the vehicle, how many passengers the vehicle carries, whether hazardous material is conveyed, and based on all that, we can determine what applies. So Part 382, the drug and alcohol stuff, is going to apply to everyone that is interstate or intrastate, but also the commercial motor, the Part 383 is a CMV driver's license. That's also going to apply to everybody interstate or intrastate, but you can still have a commercial motor vehicle requirement, be defined as a commercial motor vehicle under 382, 383, based on this section, even if you don't have any interstate drivers. And then Part 390 and 391, which apply to only interstate, so people who are crossing state lines, will have another set of commercial motor vehicle requirements as well. So typically the larger vehicles that require CMVs and they're only intrastate would be still covered in 382, 383, 390, and 391 are going to apply to all interstate vehicles, and including smaller vehicles, which is probably, this is a great slide to have it for reference. It's not something you ever need to memorize. And and so the 390 and 391 covers record keeping and driver qualification for, but only for those interstate drivers. So 382.107 tells us what a safety sensitive function is, and that's an important term throughout the regs because we call them drivers, but it's really people who perform safety sensitive functions, and that can include mechanics and people like that who operate the motor vehicle even in a yard or something. So but anytime a driver, as defined by the regs, is hanging out at the plant waiting or to be dispatched, or is on duty basically, or available on call, then they're performing a safety sensitive function if they're just sitting around. Then anytime they're inspecting equipment is considered safety sensitive functions. Certainly anytime they're behind the wheel would be a safety sensitive function. And then all other time, if they're in the commercial motor vehicle, so if they're driving in tandem or they're partners, and they're in the car, in the front of the cab, they're performing a safety sensitive function even if they're not driving. While they're loading or unloading their vehicle, or dealing with any of the things around that, checking their loads, any of that, they're performing a safety sensitive function. And if they're broke down by the side of the road, that's a safety sensitive function. So basically, if there's a truck involved, or there may be a truck involved, it's probably a safety sensitive function at some point. So what is required on the employment application? And now this is part 391, and I'm going to send everybody a link to download all the notes. So hopefully those will help. But 391.21 applies to interstate carriers. Okay, so that's interstate, but more than one state. But again, as I said earlier, you could be operating only inside of one state and still be considered interstate if, for instance, you're picking up a load that started in another state and delivering it to its final destination. You may be an interstate carrier, not just an intra-state carrier. So, but if you are an interstate carrier, you've got to have 391.21 compliant employment applications. The employment application has to be furnished by the motor carrier. It has to be completed by the applicant, not by a surrogate, and it has to be signed by an applicant. That's a requirement in the regulations, that it be completed by the applicant. So that's a bit of an issue for some of your applicants who may fill out there, have a family member who's more competent in English, for instance, complete their application. According to the regulations, at least, it has to be completed by the applicant. And it has to contain specific elements: the name and address of the motor carrier, the applicant's name, address, date of birth, and social. Now, most employers don't have the date of birth on their employment application. They're concerned about age discrimination under the Age Discrimination in Employment Act, ADEA. So most employers don't have date of birth on their application. However, the Federal Motor Carrier Standards regulations safety regulations require DOB on the application. So here's yet another reason you got to have a unique application just for your drivers. And they also have to list the addresses at which they've lived for the last 3 years. And it's got to have a date for the application submission. And for each commercial motor vehicle driver's license they have, they've got to give you the state number and expiration date of each of their active licenses, and hopefully they've only got one of them. And they've got to tell you what kind of experience they've had operating different kinds of motor vehicles. And a list of all the motor vehicle accidents in which they were involved in 3 years prior to submitting the application. So that's a lot of stuff. It's really unique to a commercial driver's employment application that you wouldn't see on a normal employment application, which is why you've got these unique ones. And they also have to have a list of all their tickets, basically all their motor vehicle violations in which they were convicted or forfeited bond, or accepted deferred adjudication, for instance, and paid some sort of fine, things like that. And if they've ever had their license suspended, they've got to give you an explanation of all of that as well. So this is quite a lot of things to have on the employment application. Then they also have to list specifically the names and addresses of all their employers during the previous 3 years, all employers, okay? And the employment dates and why they left that employer. And then for each of those employers, whether that applicant was subject to the FMCSRs while they were employed by that employer. And often your applicants don't know. It's amazing. How often an applicant will check yes that this position was an FMCSR DOT covered position. They check yes, and we call that employer, and that employer's never even heard of the DOT. And the guy was a driver, but he was a hotshot driver driving a little pickup, and none of this was done. And so it's often these drivers don't understand what the requirements are. And so you'll see a lot of them do say that they were subject to the FMCSRs when they really weren't. And they'll also say that my job was a safety-sensitive position. And yeah, sure, I did all the DOT drug testing. And in fact, maybe that employer did do drug testing, but they weren't DOT covered, and they weren't just doing the strictly 5-panel test that DOT compliance would require. So often your drivers are just kind of clueless, and bless their hearts. And if they're applying to operate a commercial motor vehicle that's as defined by Part 383, which you remember applies to interstate drivers, interstate and intrastate drivers, they would have to list the names and addresses of all their driving employers for the 7 years previous to the 3 years that they just listed earlier, if that makes any sense. Let me show you. I think I've got a slide coming up that'll maybe make more sense of it, but it's then there's a whole, that's under 391.21. Then there's a whole other section, 383.35, that also has specific requirements asking, specifically to list all 10 years, all driver positions, CMV positions in the last 10 years. So you got, again, kind of overlapping requirements. So here's kind of a little graphic to try and clarify that. So from the application date, if you look back 3 years, 391.21 requires you to list all employers, regardless of whether they operated a commercial motor vehicle while they were in that employ. Now, beyond 3 years, they have to list all employers in which they operated a commercial motor vehicle up to 10 years ago, if that makes any sense. Probably clear as mud. If you have any questions, go ahead and ask them, and I will definitely make sure we get them later in the webinar at the end here. So it's kind of a mess, right? So 3 years, all employers, 7 years, CMV employers only. Just make it easy for yourself. Ask specifically that they list everybody they've worked for at a minimum the last 3 years, and then all commercial drivers more than 7. Now, I've seen employment applications that just ask them, tell us every single company you've worked for in the last 10 years. And that makes it easy. You don't have to do any of this math. You just say, give me everybody in the last 10 years, and you ask them, did you operate a commercial motor vehicle in this job? That may be the easiest way to do it, except that, and I'm sure those of you who hire commercial motor drivers know that these guys job hop a lot. And so, you may end up with 20 or more employers listed if you ask for every single employer in the last 10 years. So that's just the one caveat I throw out there for that. So here's kind of how our employment history looks like. And like I said, we pretty much just ask for the full 10 years just because it's easier. And it gives you an idea if you've got any gaps of employment. I'm always concerned about anything that looks like a gap in employment, especially for a position like this, because I want to know that what they were doing during that time and that they weren't just cooling their heels in jail someplace. So the other thing is, you'll notice here, you could save yourselves a lot of headache if you just have that statement that every question must be answered. Don't leave things blank or see resume, or certainly not will discuss for the termination reasons, any of that stuff. Don't accept that stuff. And if you can, train whoever's at your front desk receiving these and often, HR, it's not the HR office these drivers are walking into. It's somebody at a terminal or out in the field someplace. There's no HR person on site, and applicants walk in, fill out an application, and just hand it to somebody. Well, whoever they're handing it to, you can save yourself a lot of hassle and make your background checks and your whole process a lot smoother if whoever it is that receives that will take the time to look through and make sure there are no blanks. And if they've answered every question, that 30 seconds spent by that person could save you, half an hour later trying to track down this driver and who your local manager's probably already put to work and trying to get all these questions answered. So I'm a big proponent on not accepting an application unless every single question has been answered. Okay, so there's additional requirements on 391.21 that there's got to be a specific certification. This is again interstate drivers. There's got to be a specific certification that where the driver says this application was completed by me, and that everything that here is true and complete to the best of my knowledge. So that's specific language in the regulation that you've got to have on the employment application. And then there's also got to be a statement there telling them, hey, all the information that you provide on the employment application, we're actually going to use that information to make a hiring decision, which seems kind of like a silly thing to have to say, but that's one of the regs that we're going to contact your previous employers, and we're going to make sure that you operated safely, and we're going to follow the 391.23 requirements. And there's also they've got specific due process requirements that you have to follow, and you got to notify them about those. And those include the right to review information that's provided by their previous employers. So if they come to you and say, I want to know why the previous employer told you about me, you have to share that with them. If they think there's something wrong with the information that the previous employer provided, they have the right to say, hey, that's wrong, and contact the previous employer and get it corrected. And if the previous employer says, no, that's right, you were fired for sleeping on the job or whatever, and they say, no, I wasn't, then they have the right to provide that previous employer with a rebuttal statement that they have to share in the future to tell the applicant side of the story, the former employee side of the story, every time they share this other information, which is a real hassle because you've got to find a way to either work that into your HRIS process or make sure it's in the driver investigation file or the driver qualification file, wherever you're keeping that stuff, so that you can provide it to future employers quickly. Then under 40.25, which is the drug and alcohol requirements, you've got additional requirements, and this applies to all interstate and intrastate carriers. You have to ask the employee whether they have ever tested positive or refused to test on any pre-employment drug or alcohol test administered by an employer. So any pre-employment tests, they have to tell you if they failed one or refused to take one. Okay, it's only in pre-employment. You have to ask them about that. But what's weird is the way the regs are written. You don't have to ask them if they ever passed or failed a test or refused to take a test after they were hired. It's kind of weird. It's a unique thing in the regs, but it's specifically only deals with pre-employment. But that doesn't stop you from asking that question, and I think you probably should. I would have the specific, language in there about the pre-employment failures or refusals, but I would also have it in there about any, any that were post-employment as well, or post-hire. Now, so you have to collect all this stuff on the employment application, but do you have to actually verify it, or what are the requirements? And there are two different sections that govern this. Again, 391.23, which applies to all. Well, it says all drivers here. Is really all interstate drivers. It's the broader category of those who go interstate between two states. And 40.25, which is really, I guess, what you would call the broad category. It's because it's interstate and intrastate. So let's dig into those. 391.23 covers the safety performance history inquiries that you have to make to previous employers. And again, 391.23 is interstate commercial drivers. The First of all, you've got to make these specific inquiries to previous employers, and also to the states. You have to look into for each state where the person's held a motor vehicles license in the past 3 years. You got to get their driving record for for that time. That's an easy one, right? Typically, you can do it by paper still and go straight to the state, DPS or whoever it is in that state that includes us. But most people have a relationship with a background screening vendor who can pull that immediately for them. And a lot of our clients pull those before they even start the rest of the background check, because if they don't pass muster on their driving history, on their MVR, then why spend the money on the rest of the background check and the time? And then you check, you've got to ask about their driver safety performance history with each of the employers that were DOT covered in the previous 3 years as well. And those previous employers, that can be, you can talk to them on, in person, on the telephone, by letter. You can send that by carrier pigeon if you want to, or any other means. And a lot of it's done now by fax. Forms get faxed over. The employer receives it, sits on it for 29 days, and then responds on day 30 and sends the results back. Most of that is done by fax, although there are some smaller employers particularly who require it be mailed, and I think that's just a stalling tactic. And if any of you are doing that and you've got a reason for it, let me know in the questions. I'd love to have insight into that. And then you've got to have documentation of your good faith effort to try and get this information, and who you talked to, the name and address, the dates you tried to contact them, and each attempt was made. And typically, and if you've got a background screening company doing this for you, like we do for our clients, what you want to do is make sure that they're giving you a detailed history about called on this specific day, on this date, even this time is helpful. Spoke to Joe Smith, the safety manager. He said we had to fax this information on this date, at this time, called Joe to verify he received it, had to leave a voicemail. A week later, another date, I called, left a note for Joe, no response received. And that way, so that you've got for your driver investigation file, you've got all that history. So if you are ever audited, you can say, here's all our efforts to do this. If you're unable to contact a previous employer, then you've got to document that as well. For instance, the driver gives you a phone number, and that phone number is out of service. You Google it, and you can't find that company. You check SAFER, which is the central listing of all the interstate carriers, and you can't find them there. So you just document, hey, he said he worked for XYZ trucking company, but we can't find any company like that in the city that he listed. So, and often it's amazing, but the drivers really don't know the name of the company they worked for. They called it Acme, but you look in SAFER and there's 15 companies that have the word Acme in their name. So now which one is, the one he worked at? He's not sure. He said he worked out of Dallas. None of them have Dallas addresses because SAFER lists their corporate addresses primarily. So how are you going to figure that out? So those are the kind of issues you might run into. Then, and this is one area where a lot of employers fall down, is it is considered under the regs a substantial violation if a previous employer fails to respond to your inquiry. So that's and you've got to report that to DOT if they fail if a DOT covered employer fails to respond. And so they've got 30 days under the law, and we'll get into that. But then you have to, once they fail to do it and you're not getting the information, you have to do that and then notify DOT, and that's just a letter. We've got it set up in our system as a form letter we just print out and send to DOT with. But it's helpful in that letter because DOT will actually investigate it, and often you'll get the information after DOT makes a phone call where the former employer wouldn't even return your calls. When DOT calls, suddenly, oh yeah, they're really responsive, and then you'll end up getting the information a day or two later, and they'll claim they never heard from you and all that, and that's why you need all this good documentation of all your efforts to contact them. And then this letter that you send to DOT needs to go in that driver investigation file as well. So, and this is how you make that that complaint. Notice a complaint of substantial violation, and it says in the regs you send it to the assistant administrator for DOT. But in fact, what you're really going to do is you're going to send it to the regional office, the regional DOT office for where that motor carrier's headquarters is, and then they'll open an investigation. And basically what they do is call it. They see a lot of them. I mean, they don't have time. The DOT guys just don't, they've got enough work to do that they're not going to investigate each one of these like they were major safety violations, but they will call and pester the guys and make sure that they do respond, but they're not going to they're not going to find these former employers or anything like that unless they see a really bad habit of just not responding. So, but this is a requirement that when you're audited and you've got an investigation file that's missing information from a former DOT employer, that auditor is going to want to see that you did report them to DOT. And of course, if the driver doesn't have any experience working for a DOT employer, then obviously there's nothing to verify, so you just put a note to that effect in the file. They really like to put stuff in the file at DOT. Then what are you going to ask from the previous employer? Well, there's a specific list of things that you've got to ask from previous employers who hired the driver to operate a CMV within the previous 3 years. That includes their general driver identification and employment verification information. You're required to ask them for this stuff. But what does that mean? General driver identification, name, date of birth, social, is that driver identification? Employment verification information, does that mean reason for termination or just that they were actually employed there? Salary or dates? Well, there's not much direction provided by DOT. And at a minimum, hopefully you're going to find that they did work there from the dates that they stated, and that you're going to be able to verify that they were in the role that they claimed. And then you've got to additionally have basically what this is about is their accident register. Each former employer will have an accident register for that employee, for that employee that says he was, he had this ticket, then he had this accident, he had a bump in the yard, he backed a car up or whatever. There's specific things that have to be captured in the accident register. And then there's additional things that may not be in their accident register because of the severity, but the employer kept the information in their own policy, because their own policy says we keep a file on safety issues, and they can also provide that to you as well. Oh, I'm getting a note here from some people that's saying they can't hear me. Is anybody else having a problem hearing me, or is it just one person? I hope you can hear me. Hello? Somebody drop a note to me. Just let me know if you can hear me, please. Oh, you're hearing me fine. Great. Okay. Well, it looks like maybe one person lost their internet connection or something. Good. Thank you. Sorry about that. I just wanted to make sure. Since y'all can't talk to me, I don't necessarily know. So that's those. So you've got to get their accident history. That's 391.23. But then you also have to get under Part 391.23. You have to make inquiries about their alcohol and controlled substance inquiries, and this is another one of those that kind of seem to overlap with each other, depending on what kind of driver you're dealing with. So in addition to their safety performance history, you also have to ask about their from each of those employers from the previous 3 years. You got to ask about their drug and alcohol testing history. And first of all, did they ever violate the drug and alcohol requirements under 382 or Part 40? So did they ever test positive or refuse to test? If they did test positive and y'all used a substance abuse professional and did some sort of rehab program with them, did they fail to undertake it while they were employed with you? Or you may have just terminated them, so you wouldn't know if they'd gone to an SAP or rehab. So then you just have to tell that the former employer just tell you, we terminated him, but we don't have any information about whether he completed a rehab program, and you have to get that from the driver in that case. And if he did complete a rehab program, and he stayed in that with that previous employer, then you also have to ask, did he ever have any additional violations, alcohol tests, verified positive drug test, or refusals to be tested? You have to ask those things as well. And then I got a brain dart here. The specific written consent. You've got to have a specific written consent to get this information. That the driver has to provide you, as a term and condition of employment certainly, but they have to give you in writing authorization for that previous employer to release information to you. Okay, so it's a specific consent, and it can't be that I authorize the previous employer to release information to any employer that I may decide to apply with in the future. It can't be a blanket like that. It's got to be specific to release it to a specific employer. And if you're using a company like our company, a background screening company, as your go-between on that, that's fine, but it has to name both of us, the background screening company and the prospective employer. So, for instance, our release might read, that they authorize the previous employer to release information to Imperative Information Group on behalf of, Universal Pressure Pumping or one of our other clients. So that's how that works. But it's got to be specific written consent. And now there's a lot of folklore, even among DOT auditors, about what this means. But a strict reading of the requirement says that the specific written consent has to point. It's specific in who is allowed to receive the information. It's not specific. It doesn't have to be specific about who's allowed to provide the information. So there are some employers who have this process where for every single previous employer, the applicant has to fill out a whole new consent document. And that's really kind of common out there. But when you read the regs, it's not required. And I've talked to DOT offices and auditors who say, yeah, you've got to do that. Then I take them to the rule, and they read it, and they're like, oh, okay, well, I guess everybody does it that way. But I guess you don't have to do it. And the reason everybody does it that way is because back in the day, before all this computer technology and all this fancy internet, everybody was filling out a piece of paper every time. And so, and J.J. Keller and all those guys made money selling forms. And so it was, the process was dictating how, the reason for having all these separate releases. But now, with technology and just the ability to, type on a scanned document on a PDF, a former employer name, it makes it a lot easier. you've got to provide a copy of that specific written consent to the previous employer when you ask for the information. So not only did you get the specific written consent, you have to provide it to that previous employer before they give you the information, and they should not give you information without getting that actual copy of that consent document. And here's what specific written consent means. It's a statement signed by the employee that he or she agrees to the release of a particular piece of information to a particular explicitly identified person or organization at a particular time. And this is right out of the regs, by the way. So you see there's nothing in this that says it has to name the previous employer at all. The applicant is just saying you can release this to my prospective employer, and naming that prospective employer by name. And then you have to ask about any alcohol or drug tests, verified, all those same things we went through earlier. But you notice this is a 2-year requirement where the other one was all employers in the previous 3 years. So if you're strictly an intrastate carrier, so the interstate stuff doesn't apply, the interstate requirement is a 3-year inquiry to employers. If you're strictly intrastate, you don't go outside the, your state's boundaries, then you might be only required to ask for 2 years of history. But almost everybody's asking for 3 because it's just more standard out there, and everybody's most employers that I see are treating their employers, at least on the drug side, they're treating their prospective employees as interstate. And you also have to ask them about these other violations of DOT drug testing, whether they were violated any of the requirements, if they did their return to duty requirements and follow-up tests and all of that information. So same as the other, but we're just talking about a 2-year look back now. Now here's the trick under 40.25 that's unique. If that employer received any information about a failed drug test or a fizzled the test or anything from a previous employer when that employer hired them, then they have to share that with you as well. So you can end up, even though this only requires a 2-year look back for drivers, if this guy has been consistently employed as a driver, you may end up with information from 5 or 6 years ago because it should be passed on driver to driver, employer to employer, I mean. To tell you the truth, I've only seen it a couple times, but be handed down like that. And I think it's primarily because even though we spell it out, most employers don't realize they're supposed to share that. They want you to get all this information in your hot little hands before you ever let this person drive, but they recognize that it's probably not going to happen, especially since they gave employers 30 days to do it. So it may not be feasible to get it all, but you have to get it and document it as much as you can. If you find out that they did violate, of course, the drug or alcohol regulations, then you can't use them until you've demonstrated that they've complied with until they demonstrate to you that they've complied with all the return to duty requirements. Then you've got to have a record of all this. You can store all this in what's called the driver investigation file. And you got to keep it for 3 years, a minimum of 3 years from when that employee first began working for you in a safety-sensitive function. So if you're the former employer, what are your responsibilities when you start getting those phone calls? First of all, you got to make sure you get that specific written consent. Under the law, under 40.25, you're supposed to immediately release the requested information. Now, they're not going to often do it immediately. Many employers wait 30 days to do it because for interstate carriers, they've got 30 days to respond to the safety performance history stuff. But technically, under 40.25, they're supposed to be responding immediately to the drug and alcohol inquiry part. but they don't. Then 391.23, which is, again, interstate only. The requirement for employers is, again, that they respond within 30 days of the request for both safety performance and alcohol and drug history. So you've got a different standard there for 40.25, which applies to everybody, says immediately, but then interstate says 30 days. So which one do you follow if you're the prospective employer? The best thing is to get it to the former employer or the prospective employer as quick as possible. Make sure, you got to make sure that the information you're sharing with the prospective employer, assuming you're the previous employer, is accurate. You've got to give them specific contact information. In case that driver gets that report, they need to know who to contact if they disagree with the information you provided. And you got to keep a history of those requests for 1 year, including who you release the information to. You can share this information even via email, but it can be by fax or letter or whatever, carrier pigeon. But you can, you've got to make sure that you keep that information, the safety performance history information, secure and confidential so that people who don't have any business getting that information don't have access to it. If they're not involved in forwarding this former employee's records, then it doesn't need to be broadcast all over the organization. Now, the driver does have the right to dispute information that is provided. We mentioned that earlier. And they have to submit a written request to the prospective employer to find out what was said. And they've got up to 30 days to do it. So they can provide a written request when they apply. And we've seen applicants who write on the application itself, they write on it, I want to receive a copy of all previous employer provided information, something like that. So that means the employer's got to give it to them when it comes in. And you've got to give it to them within 5 days of receiving that written request, or if it was on the application, within 5 days of receiving the information from the previous employer. And if the information on the report from the previous employer is incorrect, then the driver can dispute it back to the previous employer. And once they dispute it, the previous employer has to look at it, and they've got basically 15 days to decide whether they're going to correct the data, change it, or they're going to determine that they don't agree to change it. And if they change it, if the applicant says, look, you've got the wrong hire date for me, I was hired in January, not March, and they look at their record and say, oh yeah, we made a mistake, and they correct it to say, yeah, he was hired in January, they don't have to do anything. The previous employer, they just update it, give the new information to the new employer, prospective employer, and then they don't have to have any more conversations with the driver. However, if they tell the driver that we're not going to change something, then if they decide they're not going to make the change the driver requires or is requested, then they have to tell them. And then the driver, once they've found that out, can put in a rebuttal statement and provide that to the former employer that they have to provide, as I mentioned earlier, to all future employers. And then within 5 business days of receiving the rebuttal from the driver, the previous employer has to give a copy to that prospective employer and add it to the driver information file. So we're at an hour. Did you learn anything today? Let me launch this poll. I'm hoping somebody learned something because I did a lot of talking. And this is I will tell you, this is the most text-intensive webinar I do. I promise my slides aren't usually this full of words, but when we were designing it, we couldn't find graphics, first of all, that told the story of what we wanted it to tell. Plus, this is just so nitpicky as far as getting into regs that we just found it was easier to put the regs up on the screen, and then it makes the notes easier to use and all of that as well. So let me close. Okay, most of you said, oh, most of you are very kind to me. I always appreciate that. 85% of you said you learned something. Well, that's good. And 15% of you said, nothing new, but it was a good refresher. I'll take that too any day. And that's always better than no. I don't like no. So good. It was worth your time, hopefully. And certainly it was worth mine. I enjoyed doing it. Now let me go through the questions. If you have questions, let me go through some of these questions we've received here. Okay. Oh, by the way, before we got this webinar started, I suggested that if anybody, I just asked because a number of our oil and gas clients are closing facilities because of low oil prices, and so and I've had a couple inquiries from clients about their responsibilities under the WARN Act. The act, if you've got, I think, 100 or more employees, you've got certain responsibilities if you're going to start laying people off. And if you are, then there's certain things you got to do. And if you do it wrong, it could get expensive. So we were thinking about doing a webinar on that topic that may be helpful to you. So if you're interested in that, drop me a note in the question box there, and I will make sure I get the, we'll look at those responses and see if there's enough people to warrant doing a special webinar on that. Okay, now let me go through some of these comments here, these questions. Okay. Okay. Going through the ones that I know the answers to, and I'm going to tell you the ones I don't know. I don't mind admitting my ignorance either. I read somewhere that some states now require that positive drug and BAT results must be reported to state CDL agencies. Is this accurate? I think that is accurate, but I'm not an expert in that area because I know just enough of the DOT stuff to service my clients on the background and driver investigation file side, but I have heard that. But that's not something that's in my ballywick. I tell you what's really a good resource. There's several good groups on LinkedIn for commercial motor carriers and DOT covered employers, and one of them I think is called DOT Help, HELP. It's a LinkedIn group, and I would suggest you go out there because they've got some really good resources. Can drivers complete an application online? They certainly can. The downside to completing an online electronic application is you can do an electronic signature. Under federal law, you can do an electronic signature that complies with the Federal E-Sign Act. Problem is, though, there's no way when a prospective employer gets that specific written consent, there's no way for them to know that this is an E-Sign compliant signature, so they don't know. Then they're going to still want to see a wet signature, and that's kind of your challenge there. I want to give them, you want to get the information, and so often, and we could always argue with them, hey, this is signed under the E-Sign Act and it's legal, and go through all that, and they're going to be very risk averse and try not to give it to us because they don't understand all that. So we found it's easier if we get in that situation with those clients who have electronic applications to turn around and go back to that driver and just say, hey, give me a wet signature and fax it to me or scan it to me, and then we'll pass it on. So that way the employer can actually compare signatures. Some employers just like to do that. I have a staff of 10 in my HR group. Can I get a copy of this webinar? I have to educate the recruiters. Wow, educating recruiters, good luck with that. But no, I'm teasing, I'm married to a recruiter. But what I will do is everybody's going to get an email here later on with a link to download the slides. And I think the way it's set up is you give me a survey, a quick feedback about what you liked and what we could improve with the survey, and then you get the link to download the slides. Let's see here. A couple people said they did about halfway through lose sound. I'm not sure if it was an internet problem or not. Okay. What are your thoughts on the use of electronic signatures? Yeah, we talked about that. How long must a prospective employee wait on an employment verification before they can document it as no response, or a prospective employer wait on an employment verification? Typically 30 days from the day you requested it. If you knew when they received that request, under 391.23 they've got 30 days to get that feedback to you. Of course, it's under Part 40 again. It says it's supposed to be provided immediately as far as the drug and alcohol stuff goes, but 30 days. The requirement to report to DOT is a 30-day requirement after 30 days. Let me see. Got a couple of different questions that are similar to that one. Webinar on the WARN Act. What's your opinion of putting drivers in the trucks after the drug screen clears but pending the background check results? Yeah, that's common. Because like I said, the previous employers have 30 days to respond to the 391.23 requirements, so it's common for drivers to be put to work as soon as their drug screen clears. What I suggest, just because, if you're doing the rest of your background check, you're doing a criminal history and all of that, I would still wait at a minimum until at least the criminal history is cleared, so you really know, because you can run the driving record and it comes back immediately clear, but you can have people with a clean driving history, but you still find DWIs for them or other things that would suggest negligence when you do the criminal search. So I would suggest you wait till your criminal search is back before you put them on the road. I suggest that of all employers. Let's get the criminal done before you let this employee loose in your environment. But that's a gospel according to Coffey thing. It can take a long time sometimes waiting on those employers, so you don't want to always hamstring your employees, your ability for your company to put people to work because you're waiting on a former employer. So I definitely understand that piece. Okay, what about criminal background checks? How far can we go back? There's nothing in the FMCSRs or the DOT regs that requires criminal checks or has any limitations on what you can do. Under federal law, there's no limit on how far you can go back. Criminal convictions can be reported by me to you forever. Most of our clients do a minimum 10-year look-back period, so they're looking at every place where the person's lived, worked, attended school for the last 10 years. And then beyond that, we report everything to our clients that we can legally report. So we have to look at where the applicant lives or where the client is operating and say, okay, what are the rules in that specific state? Some states have specific requirements too. Most don't, but some do. And so you need to make sure we comply with that and don't get you in trouble. But there's no limit on how far back you can go. Now, is the information relevant to you after 20 years? Well, maybe vehicular homicide for a driver 20 years ago, I might still be concerned about that. Before I put them behind the road, behind the wheel, I'm going to definitely have a lot more conversation with them. But shoplifting conviction from even 10 years ago is probably not relevant if that's all he's got on his history. Did I understand you correctly? If a former employee disagrees with information on file, they can rebut and they can file a rebuttal. And as a former employer, we must always disclose this to all future prospective employer inquiries. Yes, that is the rule, that you've got to provide that to each future employer. And that's all the questions that we have so far. Does anybody else have any others? If so, my email's right there. Shoot me an email. I'd be glad to help you there. I know those of you here in oil and gas are probably not hiring a lot right now. And we've got a lot of our clients who are going from being recruiters to being agents of bad news and laying off people. But if you're not totally happy with your current background screening process, give me a call. I'd love to talk to you. We're a low sales organization. When I was an HR guy, and I was the guy who got all those phone calls trying to sell us this or that. And so I don't like doing that. So our whole approach is trying to make sure as we're providing good content to our audience, and hopefully when you're ready to make a change to your processes, you'll talk to us about how we can improve that. And so we're not going to be calling you and picking at you to change. All we're going to say is we're here for you if you need us, and we'd love to work with you. So if we can be of any service, my information's there. Shoot me an email. We will be sending a survey to you that's got ask for your feedback on what you thought of the webinar today, and then at the end of that, you'll be taken to a link to download the notes. And the notes there are notes on these slides beyond what's on these slides in that download, and it'll also give you the HRCI information. If you're a HR person who's HRCI certified like I am, then you can get your certification too. So we're just trading a little feedback for that certification and that download. So if there's anything I can ever do, Griselda asked one last question. Let me look at this. Can you deny employment based on criminal background? Oh, certainly. I've got a whole webinar on how to do that. You go to our website at imperativeinfo.com. And all our previous webinars are recorded out there, including this one. This one will be recorded out there and posted out there today or tomorrow probably. But there's one on creating a criminal history evaluation tool, and that's the guidelines you'll want to use when you're evaluating somebody's criminal history, and it's right out there on our website too. Other than that, feel free to call me if I can be of service. I do appreciate everybody giving us the time today, and I hope it was helpful. Everybody have a great week. Thanks a lot.